Good afternoon and welcome. My name is Erin O'Brien, and I'm a legal assistant at the Unemployment Law Project. The Unemployment Law Project has been around since 1984, and we are the only freestanding legal aid office in the country solely dedicated to unemployment. The Unemployment Law Project provides free legal representation and free advice counsel to people in Washington state who have been denied unemployment benefits or those who have been awarded of benefits, but it is being challenged. We are here today with our weekly webinar, which occurs every Monday at noon, and we're glad that you've joined us today. The purpose of today's webinar is to share the latest news regarding unemployment benefits, to provide an update on our lawsuit regarding unemployment benefits, and to answer your questions. We'll share commonly asked questions during the presentation, and I will be monitoring the chat box with Q&A to address your concerns live today. I'd like to introduce today's speakers from the Unemployment Law Project. Joining us today, we have Executive Director John Turbach and Staff Attorney and Policy Director Ann Paxton. I'll turn it over to John, and we can now get started.
Hi, good afternoon. I just want to give an update. In the summer, the Sheridan Law Firm filed a writ of mandamus petition in the Washington State Supreme Court. It asked the court to order Employment Security Department to process claims immediately and make prompt payments as required by law. Fortunately, the court did not rule on that immediately. There was some briefing back and forth and some declarations from both sides, and the court decided to send it back to Superior Court, to send it to Superior Court for further fact finding. And concurrently, there was another suit by Northwest Justice Project on similar issues. The Sheridan firm moved to consolidate both cases for the purposes of discovery. And you give any update on that? Was that granted?
Sorry, John, I got distracted with this webinar, so
Okay.
I will have to look into that.
Okay. So we're not sure if the court has ruled on it. If they haven't ruled yet, they will rule in the coming weeks. If the court doesn't consolidate both cases because they're similar issues, and the fact finding would be, concurrent, the Sheridan firm will continue with the case as a separate case after that, and we will keep you updated on that. So there's no news at the moment, but I would like people to know that the case is active and alive, and unfortunately, rather than a quick resolution, it will go the way of so much litigation, which will go on for a long time. Thank you.
Thank you, John. So I can comment on this aspect of the lawsuits. They do take time. There are some things we are working on that we hope will work faster, but they do. Some of them also are going to be extended. Extensive time will be needed to get some action as well. But here's what's happening right now, and we're hoping some of this is good news, although not all of it. So just to give you a brief rundown on what's happening at the federal level, there are a lot of question marks is the best way to way to sum it up, and about what can happen and how fast. So the after January 20th, when the Biden administration is in place, there could be action on some of the statutory changes that would be required to extend the Pandemic Unemployment Assistance Program, as well as the extension, the PEUC program, and others. But those statutes always take time. New legislation always takes time to pass. In the meantime, though, there are some policy changes that can be implemented fairly fast, probably within a week of the new administration coming in. And those have been the focus of attention of the transition team. And ULP has been assisting in a peripheral way on what those recommendations might be by going through all the policy statements that have come from the Department of Labor and asking for action to address some of the biggest problems. Unfortunately, the biggest problems are basically statutory issues. For example, there's a ban on waiver of overpayments related to PUA. That's in the statute. So we can't fix that. But there are other things we can address fairly quickly at the policy level. So in terms of the state restrictions and the lockdown, everyone's familiar with what's been happening over the last week, which is because of the sort of second surge or second or third surge of the pandemic, the state will be under some lockdown conditions. A lot of restaurants have been restricted to indoor dining, so a lot of restaurants will be closing. And one immediate impact is of the lockdown or restrictions is that about 100,000 restaurant workers are likely to lose their jobs right now. So there should be an immediate impact on unemployment claims next week. We're expecting very large increases in unemployment in Washington state, which is an interesting development because the state has just recently had a 3-month unemployment rate that fell below 8%, and that triggered a change in the length of availability of pandemic unemployment assistance, PUA, as well as extended benefits. So I'll talk about that in a little bit, but it's interesting that sort of positive trend is going to have to negatively affect a lot of people. So the latest unemployment claim reports from the state are that initial claims really remain at elevated levels, even though they've been slightly dropping. They've been rising and falling. Week before last, there was the spike in new claims, regular claims in Washington state was the highest in the country. And that has to do with a phenomenon that I will also talk a little bit about, which is this potential new claims issue requiring people to switch programs that they're in. A lot of people are in federal programs and should be in the state program. That's created kind of an artificial spike, but there is also a very genuine increase in unemployment. PUA, actually, those claims have been dropping slightly, but continued and ongoing claims for regular benefits have been on the increase. The important thing to note at this point is that the very, very significant benefit programs, PUA and PEUC, will be expiring December 26th. So that does not mean that people who applied for PUA or PEUC will not get back benefits once their claim is resolved. So if your claim has been made and your application is pending, that can still be resolved positively, but your application must be in by December 26th for that to happen. We believe. We have not heard anything to the contrary. So we have strongly recommend that anybody who has not applied for PUA and might qualify must get that application in. Unfortunately, right now, a lot of people who are getting PA are being sent back to regular benefits, which is also a good thing because that it makes you eligible for extended benefits. The main significance, though, of the expiration date is that nationwide, millions of people will be cut off from benefit programs. So that's kind of the running theme for this week's news. And everyone is likely to know that the job search requirement has been suspended again till December 7th, through December 7th. So job searches are currently optional. And we have often recommended that people, despite the fact that the job search requirement is optional, that you continue searching for work, both because you may find something that turns out to be a good fit for you, but also when if you can run into potential problems with your application or claims processing or weekly claims, there can be a lot of confusion about whether people are supposed to comply with the normal rule or with the waiver, with the suspended rule. So if you have 3 job search activities and they can be relating to your resume. They can be relating to a jobs fair. There are a lot of things you can do. Those will at least save you from that one glitch. And there's a lot of glitches in the process these days. One of them is that we're very disappointed to see still on the website that extended benefits and PEUC are listed as requiring job searches. So since that's suspended right now, it's very confusing to people. And that's one reason why it's not a bad idea to have a job search activity that you can report. The phone hours have been restored to what their normal hours are, from 8 a.m. to 4 p.m. But this week, the ESD will be closed, and the phone lines will be closed on Thursday and Friday. In addition, ESD is saying that the weekly benefit payments will likely be delayed because of that. However, ESD is still doing callbacks. They do have a limit of 500 a day, which is a little bit of a drop in the bucket compared to the number of calls that are coming in, but it is an improvement over what they were doing before. So I wanted to say one thing about emergency rules. The governor can act fairly quickly on certain kinds of rules, like the job search suspension and the waiting week suspension. And some new rules have come down on an emergency basis. They're kind of interesting, but won't affect a lot of people. One is that if you file a petition for review, for judicial review, after you've lost at the hearing level, it can now be done by email. So that is big progress, because 4 years ago, when I started working in this field, there was a lot of work being done. A lot of paperwork had to be sent by fax. So email is just now emerging into as what the primary way of communicating in the law, but it's been a very slow process. So anyway, PFRs, those petition for review, can now be sent by email. And secondly, they're making the process of reopening a claim and then backdating your claim a little bit more liberal. It's been really set up so that it was almost banned, except unless you had good cause, and it would have been very exceptional to get that, but they're now making it a little bit easier to establish good cause. But I want to note, if you apply for PUA, either now or earlier in the year, you should not have to establish good cause for a backdated claim, because the law actually requires that your claim be backdated to when you became unemployed or partially employed, if it was related to COVID. So that takes the burden of proof away from the claimant for showing that there was good cause for the backdating. So overpayments are the issue of the week. The Seattle Times did a big report. There's been stories. There will be a story in the New York Times. A lot of national attention and state attention to this really unfortunate surge in overpayment notices that people have been receiving. And in fact, ULP has written to the governor about this, asking that there be a moratorium on these notices, because they are so alarming to claimants, and the level of overpayment that people are receiving. And again, an overpayment is when you have received money by mistake or for whatever reason that the state believes that you now must repay because you shouldn't have received it. And right now, a lot of those are occurring because people are actually in the wrong program, and not through any fault of the claimants. But the federal government is very strict about requiring that your first recourse is to apply for state benefits. You have to be rejected for state benefits in order to apply for the PUA program. So where that's happening, that's happened with many people, and they've gotten PUA, but as it turns out, they should have been restored to the regular benefits program because of various things that happened over the year. Maybe some wages were reported, hours were reported that they didn't have available when they first made their application. That means they have to go back to state benefits. And there are several other reasons why it could happen. But what the ESD put on their website was very confusing to people. It's called potential new claims, when it really should be phrased something like this: we may need to switch you to another program. Please get in touch with us urgently to make sure that you don't get an overpayment. Instead, what's happening is people are told that there's some vague thing called potential new claims. And what's happening is they're getting overpayment notices because they are in the wrong program, but it can potentially, in many cases, be fixed when they are put into the correct program. So it's been a complete mess, and it's really caused so much stress to people. Just one example of what the kind of thing, this kind of sums up the large contingent of people out there who are getting these notices. My husband and I began complaining in April of this year because we were laid off because of COVID. We stopped claiming in early September because we both got jobs, right? That's how the system's supposed to work. You get benefits to support you while you're unemployed, and then you go out and get new work. But what happened here? I randomly logged into my unemployment account today, right? She's not usually logging into the account because she has a job now. And I found a notice saying that I owe them all the money that I've been claiming for the whole summer, which is an absurd amount, over $10,000. I asked my husband to check his account as well, and it says the same thing. Why is this happening? So this is mainly, as I mentioned, is happening because of the strictness of the federal requirement about getting people into the right program. That's one main reason. There's also other ways that you can get an overpayment. Maybe you made a mistake on your application. Maybe you fudged some facts. That's an area where it could be considered your fault. The state could have made a mistake as well. Unfortunately, with PUA benefits, there is a ban, as I mentioned, on waiver overpayment, which means people could be stuck with very high amount to repay. If you search, one of the commenters on the Facebook support group for Washington unemployment says, if you search overpayment on this Facebook page, you'll find about 1 million people with the exact same experience recently. So I think that sums up what's going on here. There is an important change that took place just this week with both PEUC and PUA program and the extended benefits program. And that is that because both of those programs hinge on the current unemployment rate, which has been dropping in a technical sense, not actually in a reality sense, in Washington. The availability weeks of availability of those benefits for an individual claimant have also been ratcheted down. So PEUC extended benefits were available for 20 weeks. And they have been now cut down to 13 weeks. I said PUC, but I meant PUA. PUA has been cut from 46 potential weeks to 39 weeks. So those reductions will be hitting a lot of people and will mean a shortage of benefits. So one of the things we're working on is to try to possibly get new state legislation on an emergency basis to change the way that this extended benefits program is set in terms of weeks of availability, because it can be set based on different unemployment rates, and we believe it would be more accurate to use one of the higher calculations in order to make sure that people can get 20 weeks, because a lot of people are going to need those. I should note though, when you are collecting extended benefits, and a lot of people will be switching to that program because the federal benefits will be running out, the job search may kick in. Right now it's suspended, but it may kick in. And at that point, you would be required to do 4 job search activities per week. So just a heads up for the future. Some general advice about reaching ESD, because this is one of the major complaints that we hear and cries for help that we hear from claimants, which is, I can't get hold of a human. How can I do this? And it is really ironic that we have such an investment in new IT in this state and many other states, but so many problems can only be handled by a human because there are just far too many variations on people's situations for any set of templates in in an IT system, no matter how complex it is, to manage. So what we've been advising people when they are calling the number at ESD 800-318-6022 is to try to call early. Some people advise calling a minute or two before 8 a.m. Be prepared for long delays. They are getting better. You may get a call back. If you do get a call back promised to you, be on the alert for a number that you don't recognize coming through so that you're ready to answer the phone if they do call. Be sure and check also the upload documents, quote, upload documents section on e-services, because many people are missing messages there saying that you need to send us XYZ documentation. And some people have fixed their problem very quickly that way when they've made the when they've checked in. But if you have a job and are not claiming anymore, that doesn't mean you should just drop off the edge of the earth in terms of ESD. You should really keep checking in your e-services, because for one reason is there could be an overpayment there, very unfortunately. And you want to stay in the loop on that, because they will give you a chance. They'll give you 5 days to submit information. And a lot of people have said, I didn't check for a week, and so my 5 days was up. And then you start getting the threatening collection notices. However, there has been really unfortunate advice on a lot of the part of a lot of people who've had various kinds of problems to not appeal. And that is something that really we want to strongly advise against, because you have appeal rights with a hearing officer, with the judicial system. If you meet the deadlines, when you get a notice, an adverse notice about your benefits, you have 30 days to appeal normally. With PUA, technically, because of the Department of Labor regulations, you should have 60 days for that. But say 30 days, you have 30 days to get that appeal in. If you're late, then you're going to have to do an additional, you're going to have to pass an additional hurdle, which is you have to establish that you had good cause for your late appeal. So it's very important to get the appeal in, because one reason, there are a lot of reasons, you preserve your appeal rights, and losing appeal rights is a significant setback in a lot of cases. But the other reason is that once you have filed an appeal of an overpayment, and that is what's happening to a lot of people right now, they need to appeal an overpayment, then you can call up the claims, the fraud line, and get not the fraud line, but the overpayments line, to get a stay of the overpayment collection notices, so that you won't have that harassment continuing while you're waiting for your appeal to process, which will take some time. There's be several weeks of delay once you do appeal, and it's true, it's a very torturous process, but you don't want to lose your appeal rights. So that's important. That's an important thing to remember. The fraud line is where you can get a stay of I think it's at 800-246-9763. I'll have to check on that. I believe that's the number you call to get a stay on your appeals. A stay of the overpayment while you appeal.
I popped the benefit payment control toll-free number into the comment section as well, Anne.
Great, thank you. So I wanted to mention, I think last week we showed you one of our great videos from Lavina Staton, one of our attorneys, and she's been doing a great job with some PSAs to get people aware of various problems they're running into with claims processing. And I wanted to show you one of these, a couple of these. One is on the overpayment crisis. They're very short. She got a lot of views of this. She wrote an email saying there were 12,000 views. We were really thrilled about that. And the next thing we knew, it was up to 50,000. I'm sure it's much more than that now. So I wanted to play this to give you an idea. Hold on. Let's see.
Recently, thousands of Washingtonians received overpayment notices for unemployment benefits they received earlier in the year. Many of these overpayment notices stem from federal regulations requiring the Employment Security Department to move claimants from federal pandemic unemployment assistance to state unemployment insurance. As a result, many claimants were disqualified or their benefit amount was reduced, making them responsible for thousands of dollars that they already spent on housing and food and other basic necessities. Not to mention, a lot of these workers are still unemployed or, due to our upcoming lockdown, are going to be unemployed again. And because more than 1 in 4 Washingtonians is struggling to cover household expenses, we cannot expect people to pay this back right now. That's why Unemployment Law Project is joining Working Washington's 4 demands to Governor Inslee. First, we want a moratorium on collections, garnishment, and overpayment notices. Second, we need our state to audit, review, and correct claims that have fallen through the cracks. Third, we need to prioritize paying benefits quickly. See the link in the comments.
Thank you, Lavina, if you are here. So this is a really cogent summary of what's happening with the overpayment problem and what you can do about it. And I also wanted to mention just one example of another
Recently,
another thing that Lavina has been working on, which is helping people navigate the PUA application, which is a very, very difficult, complex, and glitch-filled application. And she's already written about the problem with PEUC as a question, diverting people away from the PUA application through no fault of theirs, but it's just the way the application is set up. You have to say yes when you read the question, do you want to apply for PEUC, even though you don't want to apply for PEUC, in order to get to the PUA application. So this PSA that Lavina did is on the question on availability. This is on the weekly claims, and this is really extremely helpful advice.
Hey, are you applying for unemployment benefits in Washington State and you're confused by a question? In Section 8, your occupation, it asks whether you're able to and available for work. But what does that even mean in a pandemic? What it means is this. If it weren't for COVID-19, a layoff, or your kids being out of school, would you otherwise be able and available for work? And during a pandemic, most people are going to answer yes. My name's Lavina, and I'm an attorney at the Unemployment Law Project. Let me know if this helped, and like and follow for more information.
Yes, so please take that advice, like and follow for more information, and stay tuned. We'll have more advice from Lavina on PUA applications and possibly other issues as well. So that is the news for this week.
Before we take questions, I just want to add that I've been getting a lot of questions about what's going to happen with the new Congress and new administration, and we don't really know. I've seen some discussion of possibly putting together some sort of aid package before the new year, but other sources say that's never going to happen with the current Congress and president. And then the question is, after January, will a package be put together? Well, there will be a new president on January 20th, but the Senate is still up in the air about who will control. It's likely that even if the Democrats fall short a couple votes in the Senate, there's a couple of special elections happening that haven't been resolved yet. Even if they don't have a majority, there could be enough Republicans who would vote for a compromise package. So the question of what kind of package that would it be a new PUA? Would it be the same PUA, pandemic unemployment assistance? Would there be an extra $600? If not $600 a week, would it be another amount? These things we don't know, but I would urge you all to follow the news. And if you have opinions on this, to contact your senator and representatives in Washington, D.C. about what you think should happen.
And I'm going to go ahead and pop a link into the chat box so that all of you can look forward to how to connect with your representatives. But before I do that, we're going to go ahead and get started on Q&A. One of the first questions that we have is someone has notified us that multiple agents from ESD have been telling people that all benefits, including extended benefits, will end on 12/26. not just specific programs. Are you able to clarify if the reductions in the numbers of weeks on both the PUA and the extended benefits are changes related to the expiration date of the extended benefits? Do they fall under one category or are they separate?
So both the change in number of weeks of availability of PUA and extended benefits are happening because they're pegged to the unemployment rate. So those are definitely happening because of the rate that Washington is using as the index right now. It doesn't necessarily mean that that can't change. We would like to see the state use a different mechanism. But right now, if you are receiving PUA and you hit 39 weeks of PUA before December 26th, you will not get any further PUA benefits. If you are receiving the same thing with extended benefits, if you're receiving those right now and you hit 13 weeks, you right now you will not get further benefits. So once we get those extended, we may see a change, but that's where it is right now.
I would like to add something about my previous comment about contacting representatives. So if you're having issues with your individual claims, contacting the governor's office and your state senator and representatives is best. But my discussion about a federal pandemic relief package, those inquiries or comments should go to Washington, D.C. Senators Murray, Senators Cantwell, or your federal representative. If you're in Seattle, would be Pramila Jayapal, or it could be Representative Newhouse, or let's see, I'm forgetting some of the other names, Susan Del Bene. Those are the federal representatives who would be voting on a federal pandemic relief package that would then come to the states, like the CARES Act that passed back in March.
Okay, thank you for that, John. So we have one participant who was denied regular unemployment benefits, and they knew that they would be, and she had been receiving PUA, or they had been receiving PUA. But then they were notified that they needed to apply for a new program because they had new income. And then ESD denied them again, but then also went back and disqualified them for the PUA that they were already getting paid for. And they now have an overpayment for the whole thing. They know that they still don't qualify for the regular unemployment, but they're unsure whether they should still apply for the extension because the link continues to pop up in their account. Do you have any thoughts on this?
Well, you can't, you have to be receiving or have received regular benefits in order to get extended benefits or PEUC if you're relying on your regular benefits status. So the situation is very complicated because I'm not sure why the person thinks they wouldn't qualify for regular benefits. A lot of this is historic, right? Because you're going retroactively back to when what happened, things that might have happened in March or April. And when you were receiving benefits, they need to change the program that you were in. So I'd have to look at the original, the documents in the case to comment any further. But your claim could have been, the reason you're getting an overpayment might be because, you know, your employer did not report wages that or hours that tend to show that you actually had 680 hours and would have qualified for regular benefits. So that's the kind of situation I'm familiar with. If a person is self-employed and can't qualify for regular benefits, that might be a different situation. So I'd have to see the documents.
I would like to just add one thing in general, and we keep repeating this, but it's so important, it's worth repeating. Any notices you get, read them word for word, beginning to end. If there's anything there about asking for an appeal or redetermination or anything, follow those instructions right away. Deadlines are important, but also if an issue is resolved, let's say you request a hearing today and the hearing won't be set for weeks or maybe even months. If the issue is resolved, you can always just tell the judge it's resolved or withdraw the hearing. If there's no harm, there's no fee, there's no penalty. So it's important to read those notices, because I've talked to hundreds of people over the years who will get a notice. They'll see that, oh, you have to pay back $15,000, $20,000, $10,000, and they'll be so upset they'll just throw that paper away. And that's the worst thing you can do.
Right, and there has been a lot of advice to don't appeal. This is really not correct. There's no reason why you couldn't hang out by the telephone as long as you got time, and keep dialing and redialing ESD and hope that you get through, because there are some cases that they can fix. We have heard of those, but not every case can be fixed by the phone. So don't throw away your appeal rights, whatever else you do.
Another question that we have, there is a participant who doesn't have TikTok, but they would like to be able to watch more of Lavina's videos. Is there anywhere else that these videos are being posted so people outside of TikTok users can watch them?
If you're on Facebook, they are on our Facebook page. I'm not sure if they're on our unemploymentlawproject.org website, but you might check there. But if you're on Facebook, go to the Unemployment Law Project page. You can watch them there.
So another issue from the participant who I described with the issues with the overpayment and the extended benefits. They haven't been working because the school and childcare options are not open, and they've been saying no to being available for work because of that. But then it goes to the PUA weekly questions, and they've been saying that they're unavailable because of childcare. Should constituents who are, or participants who are running into the issue of childcare because of COVID be saying that they are able and available for work?
Yes, unfortunately they should be. And don't ask us why such a completely counterintuitive, non-obvious fact is in place, because we can't explain it, but it is a glitch in the system. Really what they mean, unfortunately, when they ask if you're available for PUA is, would you be available if it weren't for COVID? So if you are having to take care of children, if it's for a COVID related closure of the school, then you are considered available. So Lavina's video also is the one that describes what the what's going on there, and you can see that on our Facebook page for the Unemployment Law Project. But if you have trouble getting it, get in touch with us, and we'll make sure that you can get a copy of it.
And I'd like to add a couple of things. First of all, if anybody has any individual issues, complicated issues, please contact our office, Unemployment Law Project. We are getting hundreds of calls, but we have an able staff taking the calls and returning calls. So it may take a while, but you can contact us individually by email. I see that our emails are being posted, and also call our office. Now, this issue of being able and available for work, even if you're kind of not due to certain circumstances, I want to just add a few things about this that might make a little sense. I think some of this, which sounds ridiculous, like, well, why would I have to be able if I don't have to search? I think some of these go back to these federal mandate guidelines that have to be technically adhered to for federal, the federal part of the program to go through, because unemployment's a partnership between state and federal law. I think that's behind it, unfortunately. But I would urge people, because I've talked to a lot of people about this issue, and they're very troubled because people are rightly concerned about giving incorrect information. I think about it this way. I'm a father. Let's say I have, an 8-year-old and a 10-year-old, and they're doing school from home. I can't really work out. Now, am I able to work in a traditional sense? Well, maybe not, the usual job, but hypothetically, could I do a job that I could telecommute to, an online job or some other thing? Yes, of course. So sometimes if you think of it in that way, think about it in a broad sense of being available to do something, but you're available to do it. However, maybe your skills don't really fit those kind of jobs, so no one's going to offer it to you, but you are available to work even if you're stuck at home, even if you have like a mild case of COVID yourself. Yes, you are impacted seriously, of course, but theoretically, if there was a part-time job you could do from home, yes, you could. So I think that's a better way to think of it, and to answer yes to these questions and don't worry about it.
Yeah, we've heard some other examples of questions where, for example, if the weekly claim says, was your employer closed, and people would say, well, it was closed for a while, or it's not permanently closed, it's just suspended. So that's what they're looking for. Say yes, it's closed, because if you try to get into a technical distinction between closed and suspended, it's not really relevant. They want to know if there's a COVID-related reason why you're unemployed.
It's closed for you. It's closed to you, so
yeah,
it's closed.
Exactly.
Okay, so we have a participant who they received a job, so they stopped filing, and they just now learned that they have a significant overpayment. It's more than they would earn in a year at their new job. They filed an appeal. Is there anything else they should do in the meantime while they wait for the hearing date to be set? And they would also like to know if we know how other people have fared at their overpayment hearings. Generally, like, have they been waived? If they can't be waived, have the payments been retracted, etc.
Well, we do. I'll take this one from the start. So our office does many overpayment hearings. Of course, outcomes are always different. There's a number of ways an overpayment can be taken care of. It can be, for example, found that you were actually eligible for that program or another program. It can be waived, meaning it wasn't your fault and it would be a hardship to repay. It could be thrown out, or sometimes notices are invalid the way they're sent technically. They're void on their face. So that there's a number of reasons. It's good to, when you do the appeal, keep a record of that. If you're doing it online, note when you're doing it. If you're doing it by mail or fax, keep a copy. There's no harm in doing it more than one way. Another thing, we've had that call and we spoke about it earlier, contacting benefit payment control, which we put in the chat here, but is on the ESD website under contact us, and then go to for the unemployed worker. Benefit payment control is the collections folks. So there's an 800, there's a toll-free number. I think it's 866, a toll-free number, and an email there. So contact them and ask for a stay. For some reason, if you don't use the word stay, I want to stay on the collections of my overpayment, they will do it. Anecdotally, I've told people have told me that sometimes they call, they get a person who's hostile. Sometimes they call back and get someone better. So that's a hint you might want to keep in mind.
Thank you, John. So our next question is, how frequently will the unemployment numbers be assessed? Do we know if that's monthly or quarterly?
That is there's different ways to calculate it. Right now they're relying on a 3-month average. They calculate them at least monthly, but the indexes that they use have different methods of different arithmetic formulas. So the numbers are reported. It's just how they are used and which actual figures are used. Those are what count in terms of getting these extended benefits or PUA availability weeks calculated.
Perfect, thank you. So we had one of our participants who just wanted to share with everyone their experience trying to contact ESD over the phone recently, so everyone else kind of knows what that looks like. It took this participant 42 consecutive calls to actually get through twice. The first time it went to a recorded message that hung up on them, and the second time they were put on hold for 42 minutes, and then they finally had an ESD representative answer the phone, and that person was able to answer their question. It was quite helpful, but the whole thing took a bit over 90 minutes, which they said is a significant improvement comparative to over the summer when they had been making attempts.
That is better. So, but that's just one indication of how it can be very difficult to get through on the phones. So appeals are one a very, very important alternative. I wanted to mention one thing about appeals, and that we've heard from ESD. What's happening to a lot of people is there are actually multiple issues that are affecting their claim. So they may be able to appeal on one issue, and then it turns out that's still not going to mean they get benefits yet because other issues have to be resolved. So there are a lot of reasons this might be happening, but one thing that you can do if you are appealing is make sure that you check the box for every issue that is outstanding on your appeal. So sometimes people will go on the e-services, they'll just check one box. That means that only one issue might be resolved, and that could be fatal for getting your benefits in any kind of timely way. So it's one possibility that will help, but there are other reasons that are causing the problem. So we're trying to work on those.
And to build on that, I have noticed that we have had a couple of repeat or similar questions where people have been denied, but they're confused on how to send in their appeal because they haven't been able to find the ability to do so on their e-services. Could one of you address how one might go about sending in an appeal for a denial?
You should be able to fax it in.
On your notice, there should be a mailing address, a fax number on that. There's a PO box in Olympia for the filing of the appeal, and also a fax number. They can contact us individually. We can give that. I don't have it memorized, unfortunately, but it should be on that notice, on that letter of determination.
Yeah.
Also, the reason why it's important to appeal everything you disagree with is it's been a common problem for years for us to, at the Unemployment Law Project, get a case, and we take the case, and luckily it comes out in the person's favor, and then there's no money, for example, and like what's going on, and then there's further investigation. We found out that there's this other notice that they never got or didn't know about, and then you have to appeal that one too and go through another hearing. And so the more you can do up front, the better it is.
Okay, so another question that we have would be when a participant is being interviewed by the claim investigation services, like an adjudicator, for example, is the person doing the call recording the call? She knows, or they know that notes are being taken. But at one point when they were being interviewed with an adjudicator, that adjudicator referenced back something that the claimant had said to a different adjudicator at a previous date. So they wanted to know if that is being recorded or the notes are extensive, could the participant or claimant actually get copies of them for their own notes, potentially to be put forward at their hearing?
John, do you know if they're recorded? I really don't.
I have not heard of them being recorded. My understanding as a general principle is that, I often do this when I call, any hidden number for my credit card or any other customer service. Often there's that warning, your call may be recorded for training purposes or quality control or something like that, because I believe that that if you're going to be recorded, you should be informed of that. That's like, for example, if you're leaving a message for someone, you're being recorded, of course. So I know they make notes, and I know that if somebody's talking to you, they're, I'm sure, looking up the notes of the prior call. So that's accessible to them because they are trained to make notes. Recording, I don't know. But as far as getting a copy, I know people do public records requests. And I'm not, Anne might know a lot more about that than I do, but like in terms of, just requesting your own records, because when you get a hearing, maybe I'll give a longer answer here. They're kind of good. Usually, let's say you get a hearing, and what's typically in a hearing packet you get before the hearing is the hearing notice, the letter you're appealing, your appeal letter, and there might be other documents that either you sent in, or if there is an employer involved, documents they sent in. and then maybe some of the notes from employment security. But people have told me over the years, well, they're missing information. It may not be intentional on the part of the department, but I think those can be gone through a public records request.
Right, and I'm looking up the contact person for public records request, and I will have to do that on the next question. I do want to mention, though, that when you file an appeal, you will get an exhibit packet, and so will the employer if there are other parties involved. And that will contain the adjudicator notes. So they do try to take extensive notes. You can get those notes through filing an appeal. And I do want to mention, in addition, we've brought a lot of these issues up with ESD, and they say, well, we've hired a lot of new people and they're not always on top of all the issues. And some of them gone through 2 months of training, but it is very complex. However, a lot of times people are getting very bad advice from the claims agents who are handling the phone calls. And they might say, oh, if you have filed an appeal, we can't talk to you, which is totally not true. So it's leaving a lot of confusion, a lot of distress in the wake. So just be aware that not every claims agent is going to be giving you accurate information.
So we have one question. One of our participants is receiving their regular UI claim, but they're confused about the term of this claim. They're referencing a 6-month or 12-month term, and they are asking if all claims are considered for a 1-year period. Therefore, if there are weeks that are unused, would that roll over into the new year?
So this is kind of complicated. So if you have unused weeks, for example, on a PUA claim after December 26th, those can't be used. If you have hit your 39 weeks on PUA, you won't have any further PUA payments. So I'd have to see the documentation on this to kind of answer that question.
A typical regular unemployment claim is 26 weeks. And then with any extensions that may be in effect at that time, depending on what the unemployment rate is. So 26 weeks is the basis. What's confusing, and I want to put this out, is a lot of, when you file a claim and when you get documents from them, there's a thing called BYE, which is benefit year ending. And that's confusing because some of these, let's say I filed for unemployment in November of this year, and I'll get a document back and they'll say BYE of November of 2021. It doesn't mean the claim is for 50, something weeks a year. So I don't know why they have that terminology. Anne might know, I don't know, but it's just, it's very confusing. But think of a regular claim as 26 weeks, and then PUA is it 30?
PUAs will be 39
weeks, and then whatever extensions might be added onto that.
Thank you. Okay, so it is 12:55 right now. I think that we're only going to have time for one more question. So I put everyone's emails in the chat, as well as a link to our website that refers you to emails for other staff members as well. We have a participant who's wondering, given how crazy and complicated everything is right now, is it worth filing for unemployment benefits if they do in fact have a job? They are a substitute teacher, but the opportunities have been cut back pretty significantly, so they haven't been getting the same amount of pay or hours, and they are struggling to pay the bills.
So it's certainly worth trying, especially if you're not exactly sure how much employment you're going to have. Opening a claim can be open for a year. If you stop filing for 4 weeks, you'll need to restart it. But once you have a claim open, you would have the option to file. And if you have a bad week where you're not getting very much income, that could very well be something that was helpful. And if you do earn some money, part of that, 75% of that, has to be subtracted from your benefit. But that still leaves a few $100s most people could collect if they don't have a lot of work at the time.
So one thing I like that is it's important that when you do report that income, you report it when it's earned, not when it's received. So if you worked 10 hours this week at $20 an hour, that's $200. If your unemployment claim was for 500 a week, there would be a calculation, as Ann said, 75% deduction, but don't worry about the math. Let them do the math. Your job is just to report it accurately. Some weeks your benefit might be zero. If you have a good week and you work 5 days, you probably won't get a benefit. Well, good for you. You have income. Maybe the next week there's no job as a substitute. So unfortunate thing about being a substitute is they usually enforce the rules about reasonable assurance. So which means that school employees in general cannot get benefits during break times, winter break, spring break, summer break. It's important to apply anyway, of course, just to try to get it if you can, because the school might have not given proper reasonable assurance. But in general, school employees can't get unemployment during breaks. But through the regular school year, substitutes that I've talked to many have very fluctuating income, and it's worth applying.
All right, I do actually have one last question. It's very quick. I'm pretty sure I know what you guys are going to say. We have a participant who wants to know, should they wait until after the holidays to send in their appeal, or should they get that in as soon as possible?
Definitely get
Right
it
away.
Yesterday.
Right away. It's been taking weeks and weeks and months for some cases to get the hearing set. I would not wait at all.
I can speak to this a little bit if that's all right with the two of you. Okay, so what I have seen is that there's generally been a 2-month processing period for your appeal just to be handed off from ESD to the Office of Administrative Hearings. That means that your appeal will stay at the Unemployment Security Department for probably 2 months. In that time, they might redetermine it, and that might change the outcome, and it might not need to go to a hearing, but that's not a guarantee. If that doesn't happen, then your hearing or your appeal just gets to the court system in order to have the hearing scheduled in 2 months. So you want to get that appeal in to get that clock counting down as soon as possible.
And what she describes, what Erin describes, is consistent with what I've heard. And yet there are some odd cases where people get hearings right away. I don't understand how that happened or why that happened, but I'll talk to somebody who will get a hearing in a few weeks, and I can't figure out why that is. So it's unpredictable. The important thing is watch your mail very carefully, because the hearing notices are sent by U.S. mail, and so you want to have a correct address. And because sometimes you'll get a hearing date and the hearing comes up very quickly, and if you don't check your mail on a regular basis, you can miss it.
Right. The majority of people that I've heard about lately are saying right now they're getting scheduled in February. So once it goes to OAH, and that's once it gets to OAH. So it's really quite backlogged. Don't waste any time getting an appeal in.
To build on John's point real fast about the hearing notice in the mail, another really good way to stay on top of that information is to call the Office of Administrative Hearings maybe once a week, just to be like, hey, have you gotten my appeal yet? Once they say yes, you can start calling to be like, hey, have you scheduled my hearing yet? Because you could be checking the mail very reliably and have all that information up to date, and still find out pretty last minute that your hearing has been scheduled, whether that's through some issue with USPS or just unforeseen circumstances. So the most reliable way, in my experience, to keep on top of that is to call them and ask. Once your appeal has gotten to the Office of Administrative Hearings, they can set you up with a portal, so you can start checking that online. That way you can also be looking to see if it's been scheduled virtually as well.
Yeah, it's good advice.
Cool. But I believe that is all the time that we have, as it is 1:01. Thank you so much, everyone. I see that there are a couple of extra questions that we didn't get to. Please feel free to email us to follow up on them. And I hope you guys have a great rest of your week, a safe week, a great holiday. All right. Thanks, everyone.
Bye. Thanks.